I stood up in court a week ago and said, until we get disclosure of all the documents, relevant documents, we're not going to be in a position to cross-examine the remaining two police liaison team officers.
Robert Krajcik here in Ottawa, Ontario, reporting for Rebel News at the conclusion of the 24th day of the trial of Tamara Lich and Chris Barber. The two co-defendants are being charged with crimes related to their roles as organizers with the 2022 Freedom Convoy. You all remember it. It was a peaceful demonstration here in downtown Ottawa, opposed to what I regularly frame as the COVID-19 enterprise. Series of decrees, edicts, mandates, restrictions, and of course, lockdowns. So the day's proceedings were dedicated to dealings with ongoing disclosure disputes between the prosecution and defense teams. We had a little bit of resolution on that. We're going to get into that in a moment. I got a quick moment with Lawrence Greenspan, defense attorney for Tamara Lich. But before we get there, I just want to remind you folks out there in the audience, we need your financial support to continue delivering this in the field, on the ground reporting that you can't get anywhere else. So please help us out and also stay up to date with our ongoing reports at tamaratrial.com. The judge's decision on the pending disclosure dispute regarding the documents that were claimed to be protected by solicitor-client privilege. Do you have an expectation that she'll render her decision tomorrow? She said she wanted to do careful consideration of this.
No idea when she's going to give that decision, but she's very well aware that it's important that that decision be given as soon as possible.
The last question, just in terms of the urgency that you're alluding to, is it because you do not want to proceed with cross-examination of future witnesses until the decision's been rendered with respect to disclosure of this document?
Exactly. I mean, I stood up in court a week ago and said, until we get disclosure of all the documents, relevant documents, we're not going to be in a position to cross-examine the remaining two police liaison team officers.
We're here with Adam from the Democracy Fund. I'm a huge fan of his. I want to get his legal insights because he's a lawyer into one of the disclosure disputes that was resolved today. So there was this 5-page document. It was fully redacted, and it was finally disclosed by the judge to the defense teams. Can you walk our audience through that process? What exactly happened, and how did the judge arrive at her decision to rule in favor of this full disclosure of the document?
Yeah, so sure. With respect to that document, there were two applications made by defense. First, on a first-party basis, that they wanted the document fully unredacted because they contended that the Crown was in possession of this. As soon as the Crown came to possession of this document, it becomes a first-party record. They also alternatively made an application for a third-party records production. This is and that's what the decision that Perkins McVeigh made, was that this is not a first-party record. She found that it was a third-party record. Nonetheless, she found that it met the test. And she had it immediately produced to defense. So we saw that document. After some review of Perkins McVeigh, she made that decision. That document has now been produced to defense. Defense then went on to request some time to review it. Obviously, they're going to need some time to deliberate and think of questions on cross-examination. And then we still haven't heard an answer with respect to two of the email exhibits that have been the most salient one is the, of course, solicitor-client privilege email. Justice Perkins McVeigh is going to take some more time to deliberate on that one. We're hoping that she makes her decision tonight, or has a decision ready to go for tomorrow morning, so we can get into cross-examination.
The day's proceedings were entirely consumed basically by ongoing disclosure disputes, one of which was resolved and one of which is partially resolved. Let's start with the first one. There was a 5-page document that was fully redacted that the defense sought to have fully disclosed to them. This 5-page document came into the possession of the Crown inadvertently, according to the Crown, and the Crown said that since it was inadvertently in their possession and it belonged to someone else, that the defense had to submit a third-party application in order to obtain it and request disclosure of that document. In other words, the prosecution said this document is not ours to disclose and we were not meant to be in possession of it. So the defense did submit a third-party application in which they need to demonstrate to the judge that this document of which they're seeking full disclosure is likely relevant to the trial at hand and to their defense argumentation. So the judge took a moment to go into her room, into her chamber, and review the document. She came back and decided that it would be fully disclosed to the defense. Now, the second dispute that is still ongoing, let's say partially resolved, there is this email chain between Ottawa Police Service officers who work with the police liaison team. To remind you, this PLT team, they coordinate with stakeholders and special events. In the context of this trial, PLT officers directly communicated with, coordinated with, and spoke with organizers of the Freedom Convoy, specifically Chris Barber and presumably Tamara Lich. Now, we've had two of these PLT officers invited as witnesses to this trial who said that their work phones were wiped. They lost all their data after their phones underwent some sort of software upgrade. This document that the two defense teams are seeking to have fully disclosed to them is claimed to be protected and confidential by the Crown via the Ottawa Police Service by solicitor-client privilege. In other words, lawyer-client privilege, attorney-client privilege. Now, what is the basis for that claim? These emails between police officers contain within them guidance and directives provided to the police officers by the Ottawa Police Service's legal department. Now, the defense is countering that, saying that communications between police officers, or more broadly, communications that don't involve lawyers, cannot benefit from the protection of solicitor-client privilege. But again, the Crown is maintaining that even though lawyers are not included on these emails, either as senders or recipients, the fact that the nature of these emails, the content within them, pertains to legal guidance that these Ottawa police officers received means that these emails, this email chain, should be kept confidential. Now, since this is a sensitive issue, the judge herself said that solicitor-client privilege is basically a sacrosanct concept and a sort of bedrock principle of Canadian jurisprudence. She wants more time to review it. She didn't want to render a decision on this disclosure dispute today. So she didn't. That's where we have the partial resolution. But we asked Lawrence Greenspan, Tamara Lich's defense attorney, whether or not he expects that to be delivered tomorrow. You'll see what he says. Basically, the defense wants to get a decision on this disclosure dispute, one way or the other, before they decide to proceed with cross-examination of the latest witness, another OPS officer who worked with the police liaison team. If you folks out there appreciate these in-the-field reports that we're doing, please assist us. Financially contribute to Rebel News and stay up to date with our ongoing coverage at tamaratrial.com.